during COVID, I came in 95% of the time because my husband, before he retired, he works from home.
We have our city attorney and we have all of our council members. So we'll go ahead and call to order. Let's go ahead and take a quick roll call vote or a roll call for the council members.
Councilmember Alvarez.
Present.
Vice Mayor Rogers.
Present.
Mayor Rogers.
Here.
Let the record show that all committee members are here. Thank you.
Excellent. Before we go to public comment, I just wanted to welcome everybody. We are doing this as a Zoom meeting this week. And I think we have our now normal date and time back to having a regular schedule for the Open Government Committee. So I hope folks will keep an eye on that one. What are we at here? Is it the fourth Monday of each month? Is that what we're trying to do consistently from here on out? So I hope folks will take note of that moving forward. We'll start with public comment for non-agenda items. For folks in the public, this is your time to talk to us about anything within the committee's jurisdiction that is not on today's agenda. Go ahead and hit the raise hand feature on your Zoom.
There are currently no hands raised at this time.
All right, we'll go ahead and keep moving then. So Madam City Attorney, are you gonna walk us through item 4.1?
Yes, I am. So
go ahead and take it away.
I'll take it away. The mayor has suggested that we take a look at our ordinance, our lobbying ordinance. So I have put together a quick PowerPoint. I don't know if we can get that up. And then we can talk about what changes, if any, the committee would like subcommittee would like us to look at. I'll just walk through this, but feel free, if you have questions as we're going through it. So the lobbying ordinance is City Code Chapter 10-35. And next slide. It does include a statement of the policies that it is addressing, and that is citizens have the right to know the identity of interests that are attempting to influence city decisions. All lobbyists must be subject to the same rules. There should be a complete public disclosure of the full range of activities and financing of lobbyists, and that those disclosures should be adequate and effective. Next slide. So what's encompassed in the lobbying ordinance? First, we really look to the definitions in chapter 1035, and we did. Thank you to Madeline. Did forward copies of each of the ordinances to the council members, and also it is uploaded online as well for the public. So what is lobbying? It's any oral or written communication, very broadly defined, made directly or indirectly to any city official in an effort to influence the official regarding an action on any municipal question. Next slide. So that raises a question: is what is a municipal question? It is a public policy issue, an issue of public policy, general policy of a discretionary nature. That means that the decision-making body has discretion as to whether to adopt or modify or repeal a public policy. That the question is pending before a city decision-making body, and that can be the city council or any of its subordinate bodies or committees or commissions. It does not, however, include day-to-day application, administration, or execution of city programs and policies. And the prime example for that is zoning and planning applications that are being heard by a decision-making body. The individuals that are arguing for or against those applications are not subject to the lobbying ordinance. What is included in municipal questions are broader questions of policy. So ordinances, general policy resolutions, general plans, specific plans, that more broadly applicable matters. Next slide. So what is a lobbyist? Obviously, a lobbyist is someone who is engaged in lobbying, either directly or through the acts of another, again, communicating with a city official for a particular result, and is doing that for compensation. And the compensation can be anything of value. So it can be money or any other item of value. And it can include also contingent payments. So if the arrangement is that the lobbyist will get paid or the individual will get paid only if they are successful, that still counts. Next slide. So registration is required for lobbyists. They must register with the city clerk. The registration includes the name, the address, the phone number of the lobbyist. Also the name, the address, the phone number of the person or entity that has hired the lobbyist to advocate. And then a third must identify the action, the legislative or administrative action for which the lobbyist has been engaged and is actively advocating. Next slide. The registration must be filed within 15 days of the initial engagement, and it must be filed annually thereafter, each January, between January 1 and January 31st. And if there are any changes in the lobbyist's engagement, they get more new clients, they lose a client, they add issues, take away issues, they must update their registration within 15 days of that change. Next slide. There are a whole list of things that are not included and not encompassed within the ordinance. So lobbying does not include just a simple request for information from either a decision-making body or any employee. Does not include any communications from a public official or employee acting in an official capacity, public entity employee. It doesn't include news gathering or reporting, doesn't include public speeches, articles, or publications. So if someone does a close to home article, that is not considered lobbying. Someone gives a speech advocating one way or another, that is not considered lobbying. Also, a formal petition for official action, it's not included. Next slide. Lobbying also doesn't include any information that's provided by an individual in response to a request by a city official. Also doesn't include communications in response to a general public notice that solicits public comment. And those communications go directly to a designated official. So if we post something and ask for public comment on a new ordinance, those communications that are directed to the designated official are not encompassed within lobbying. Lobbying also does not include testimony from a fact witness or an expert witness in any official proceeding. And it also does not include any advocacy that's made on behalf when an individual advocates on behalf of themselves or a relative. That is not included. Next slide. So this is really parallel. This is that the registration is not required for certain categories of individuals or organizations, and it really parallels some of those earlier exclusions and exceptions. So registration is not required to public officials acting in their public capacity. Again, mirrors the earlier provision. Doesn't apply, registration is not required for newspapers, radios, or television. Not required for persons that are invited by the city to give testimony. This next one is not included in the earlier list, and that is registration is not required for professionals that are licensed by state licensing organizations. So that would include lawyers, engineers, and surveyors, anybody else that is licensed at the state level. Next slide. Also, registration is not required for an employee of an organization that is appearing and advocating on behalf of the organization's own project. It also does not apply to representatives of our unions, our recognized employee organizations. And it also does not apply to nonprofit organizations unless they are, the individual or organization is lobbying for a specific project, issue, or person for which they are receiving, the organization is receiving compensation. If the organization is receiving compensation in that situation, they do need to register. Next slide. And finally, we're to enforcement. Enforcement, if there is a violation of the lobbying ordinance, the city clerk sends a notice of registration required. And the individual or entity has 15 days to respond. And they can respond by demonstrating that, by bringing themselves into compliance with the ordinance, or by establishing proof that they are exempt from the ordinance. Any continued violation after that is a misdemeanor, and it is punishable by up to $1,000 fine or 6 months in jail, or both the fine and jail time. And next slide. Questions. As I said, it would be a quick summary of the ordinance. So happy to answer any questions.
All right, Councilmember Alvarez.
Thank you. Could you give us an example of where a council member is in violation in regards to lobbying?
Well, the council member would not be in violation of lobbying activities. It is the lobbyist that needs to register and keep their registration current. It is the lobbyist that is in violation, and not the either individual or body of the city that is receiving, that is hearing that advocacy. So,
In which case, if you know, we're approached by a lot of our constituents in acting in our capacity. I, for example, have reached out to my appointee on the planning commission to ask a question about a project, and I imagine that's in the course of my duty, I would imagine, right?
yes. Public officials are not subject to the lobbying ordinance. So yes, you can reach out. You can also reach out to other, other boards and commissions, not directly to your own representative, but you would be able to advocate. So.
All right, thank you, sir.
Sure.
Vice Mayor, any questions?
I was wondering, probably because me and Eddie are pretty new at this, when do we know if and when we're being lobbied? Probably would be a good question for us, because we don't know when people are just talking with us or when they're actually lobbyists, because we have a lot of people that just try to get our ear also.
Right. And it is sometimes hard to know, but in general, kind of the rule of thumb for those generalized policies, it is very difficult to know, because it depends on whether the person's being compensated or not. So it's a little awkward maybe not, to ask, are you speaking on your own behalf, or are you speaking on someone else's behalf? I think you could legitimately ask, it's legitimate to ask that question, and whether you're comfortable, but I think you could be comfortable in asking that question. And if they're speaking on behalf of someone else, find out who they're speaking on behalf of. And, I think when it's project specific, those project specific applications are generally not subject to the lobbying ordinance. And those, I think, tend to be a little clearer. You don't know whether they're being compensated or not. But if there's a lawyer that's speaking, of course, lawyers aren't subject to it anyway, but if there's someone who's speaking on behalf of a project that is not a part of the applicant organization, then they're likely a lobbyist. The tricky part does become when we're going through the general plan and we're being lobbied this way or that way for on an element of the general plan, or an element of the specific plan, or a new ordinance. For example, we'll be coming forward with the vacation rental ordinance. And so to know whether the individual is speaking on their own behalf, or is being paid to speak on behalf of an organization or others. It can be helpful for you to know that. I don't know if I answered your question, but the question, the answer really is, it's difficult to tell. And if you are comfortable asking if the person is speaking on their own behalf or on behalf of a client, you're certainly free to ask that question.
Any other
You can
questions?
also, I was just going to say, you can also reach out to the city clerk's office to see if someone has made an appointment with you. You can check with the city clerk's office to see if they are registered as a lobbyist. That doesn't necessarily, a lot of people don't register. So, but if they are registered, that'll tell you that they're speaking on behalf of, and they'll identify who they're speaking on behalf of as well.
And conversely, if you are speaking to somebody and you find out they're a lobbyist, if they aren't, you can always let the city clerk's office know, let me know, and then I can reach out to that person, letting them know of our lobbyist requirements to register.
So Sue, how does it work for broad interest groups? So like, for example, the chamber advocates, but not a specific business. Typically, you've got housing groups that advocate for housing broadly, but not specific housing policies. Does it literally come down to whether or not that specific project has donated to that group or paid membership dues to that group?
No, I think it's a little trickier than that, because if they are, if it gets a little bit tricky, because people will donate to those organizations because they speak on their behalf, but they may not be donating with respect to a particular item of advocacy. So those are generally going to be exempt. I also would note, and I'm looking back at the list of exceptions. So would be nonprofit organizations, like I'm thinking, for example, I believe that Gen H is a nonprofit organization. I don't know that for a fact, but I believe that they are. So they would be exempt from the registration requirements unless they've been paid by someone on a specific project to advocate on that specific project, issue, or candidate. So.
Okay. You mentioned that.
And it's kind of difficult for you to know if that's the case or not, unless you ask. So.
Yeah. And then you mentioned that attorneys were exempt. Is that only when they're acting within the capacity of an attorney providing technical direction?
No, because part of a lawyer's work is not just providing the technical direction, but is also they are advocates. We are advocates. In the role of the city attorney, we're only advocates when we're talking to people outside. When we're talking internally, we're just trying to give you the framework and the facts and the law. But in general, advocacy is part of an attorney's work for their client. And I'm just looking at because I know they listed, yes. So the registration does not apply. The wording of the ordinance is to a person who is a professional licensed by state licensing organization, including but not limited to attorneys, architects, and engineers. And as long as the attempts to influence, I didn't get into all of the nuances in the PowerPoint, trying to give an overview. But as long as you're appearing at a public meeting, or official proceeding, you are preparing or submitting documents or writing for use in the public meeting The public meeting obviously is open to the public. And you are contacting city employees or agents working under the direction of the city manager, city attorney. So in general, yeah, attorneys can go ahead and lobby without having to register.
What was the thinking behind that, if I can ask?
I don't know. I wasn't here at the time that this was adopted. My guess, my gut reaction is that if an attorney is appearing for you, unless they specifically say I'm speaking on my own behalf, they are generally here representing a client. So you would know that it's very likely that the attorney is being paid to make the arguments that they are making. Again, unless they specify that they are speaking on their own behalf or on behalf of family. So.
And then we had an issue just a couple of weeks ago.
Yes.
Where somebody was accused of having not registered. And if you can point us to, I'm trying to remember what it was. I apologize. I meant to go back and actually watch that section of the meeting again. I think it was development deals are exempt from the lobbyist ordinance.
Yes, I remember that instance clearly because I was not fully attuned to the nuances of the lobbying ordinance. But yes, what that is that is the rule that the lobbying ordinance only applies to municipal questions. So the municipal questions are those that are broadly applicable policies, general plans, specific plans, policies that apply just generally. It is not, and I'm going to pull the specific language if I can. It does not include, so I'll give you the full list, but it does not include the day-to-day application, administration, or execution of city programs and policies, such as permitting, zoning, and planning matters. But it does include the amendment, modification, or revision to the city's general plan or zoning ordinance. So anything that's on that higher level and is not project specific. That being said, it also, the municipal question does include, and I'll just read it, proposed action or proposals for action in the form of ordinances, resolutions, motions, recommendations, reports, regulations, policies, nominations, appointments, sanctions, and bids, including the adoption of specification, awards, grants, or contracts. Now, to me, the approval of a contract seems to be a day-to-day application, administration, or execution of city programs and policies, but the ordinance itself makes that distinction. And the only specific things that they call out as day-to-day application, administration, or execution is permitting, zoning, and planning matters. And the case that we had a few weeks ago, it was a individual that was advocating on behalf of a cannabis dispensary. But again, it was in the context of a planning application for a use permit. And so it was exempt from his work was exempt from the lobbying ordinance.
Okay. Counselor, are there any other questions on this item? All right, we'll go ahead and go to public comment on it before we bring it back for further discussion and direction to staff. So we'll start with Gregory.
Gregory, you can go ahead and unmute your mic. You have 3 minutes to speak. Feel free to state your name for the record.
My name is Gregory Farron. I just want you to know that up until about 30 seconds ago, nobody could get into the Zoom. Your staff sent out a new link and I'm now in Zoom, but Pat's still over in YouTube. And so Okay, well, now she's saying she's here. I bring that up because earlier you had a public comment on items not on the agenda. Nobody could get in at that time. So that's probably why you had no one who was raising hands. You should just be aware of that error, which caused the public to be frozen out of the system. We can now be in, and I guess my comment about what you just described is it makes no sense to me that lawyers and architects and all the rest should be exempt from registering. They're doing exactly the thing that you're trying to identify lobbyists for. They're being paid to say what they think, being paid to think about a project. And there's no difference between a paid lobbyist in a very narrow sense, someone who's there to make a case and is going to get paid if it's successful. Lawyers and engineers and architects are the same folks. They just evidently got themselves exempted by putting in the ordinance in some oblique way. I think everyone who gets paid to give you an opinion on a project should register. You should know whether the motivation of their words is, from their heart as unpaid volunteers like the rest of us, or, corrupted to some degree by the fact that they're going to get paid if they're successful. That's the whole purpose of identifying and registering lobbyists. And that's all.
All right, thank you so much, Gregory. And I apologize for any error that made it so that folks couldn't jump in. We'll add on after our items 4.1 and 4.2 an additional public comment for non-agenda items, period, so that folks can weigh in at that point as well, just to make sure everybody gets to be able to say their piece. Are there any other hands for this item?
There are no hands raised.
All right, I'll go ahead and bring it back. So Sue, this is obviously just the initial discussion. We don't have any language being proposed in front of us. What would be helpful for you and the staff to hear from the subcommittee members in order to move forward?
Well, what we'd like to hear is, are there any changes that you would like to make to the lobbying ordinance? And if so, what are the areas that you'd like us to look into and to come back with some proposals? If you have specific changes that you would like, we're happy to hear those as well. But if you just want to say more generally, we're concerned about this provision or that provision, we can come back with some alternatives.
Great. We'll start with the Vice Mayor.
Why exactly are there exemptions? And if there's not good cause, maybe we should get rid of those.
I'm not sure if that was a rhetorical question, if you were asking staff to actually respond to it, or
No. She knows what I'm talking about. I'm talking about like the lawyers being exempt. Why are they exempt exactly? If she can look and see if there's like notes somewhere about exactly why they are exempt. Okay. And if there is not good cause why they are exempt, then we need to get rid of that. Or I propose that we look into getting rid of that.
Yeah.
And may I follow up a little bit on that?
Yes.
To confirm, we'll look over that list of exemptions. We'll see if there's anything in the if we can get a hold of the staff reports and any other explanations of why it was crafted the way it was, and we can report back to you on that. And then if there are particular, we can do that generally for all of the exceptions. I think about 8 or 10 categories. But are there particular exemptions that are of concern? You've mentioned the lawyers, and does that also will look at licensed professionals in general? And are there other categories that were listed as exemptions? Are there other categories that are of particular concern?
Well, I just think that we should be able to justify why we have particular exemptions.
Okay.
Honestly.
Okay. Councilmember Alvarez.
I do understand the purpose of requiring all individuals, whether they be lawyers, whether it be paid, or even on voluntary, who is representing who. Although I may not understand it fully, but for a for an individual to advocate on behalf of a permit applicant, I do see the difference between the permit application, and requiring or asking a lobbying of a changing of a zone, a changing of a zone. So for me, I think I'll be on the page that all those individuals who are lobbying for another person be required to register, whether they're paid or not. I do see the purpose of identifying individuals who are speaking for others. So I think I would like to see more transparency in the process. I think that's what it ultimately comes down to.
Okay. So we've talked about this a little bit. Part of why I wanted to put this on for discussion was the exemption section, to make sure that we're addressing that. In particular, I personally think that the time where this is the most necessary involves either the approval of contracts or development, approval of development. So I do think that it should extend to those areas as well. So I would be interested in hearing what the interest was in each of the different exemptions. To Gregory's point, we're trying to make sure that the public has a better understanding of who's being paid to do what and why they're influencing. I also am in particular most concerned about the areas that the public can't see, and that applies to lobbying staff. So the ordinance is specifically about people lobbying council members, which oftentimes is far more public than the creation of staff documents and staff recommendations, our staff reports for each of our items. And so my interest is that the lobbyist ordinance should extend to staff as well. That if somebody's if somebody's being paid to influence and work with staff and is going to influence the staff report, which is going to influence council members, that should be an extension as well. I also know that based on the state lobbyist ordinance, lobbyists are barred from donating to state legislative campaigns. And I've always thought that was a fairly good rule for the local level as well, that if you're a registered lobbyist for the city, you should not be donating in the candidate races. And so those are the ones I'd throw on the table. I'd also point to that state lobbyist ordinance and say that in general, we should review and make sure that we're meeting or exceeding most of what that ordinance is what that state law is trying to accomplish as well. Make sure that there's some congruency there for it as well.
Okay. And let me clarify with respect to lobbying of staff. City officials do include higher level staff, but not lower level staff. So it includes city manager, deputy city manager, ACMs, director, department directors, police chief, police captain, fire chief, city attorney, city clerk, zoning administrator. But we can look at having it apply just across the board to all employees, since you are right, the beginning work begins with staff. And then with respect to the state lobbying, the restriction on donations to campaigns to candidates, would that also extend to contributions to measures, or just to candidates?
I'm most concerned with candidates.
Okay.
I'll leave it up to my colleagues to see what they think about measures. Typically with the measures, the reporting requirements are a little bit different as well. And I'm sure we'll get into this a little bit in our next item, but I was thinking in particular to candidates.
Okay.
Okay. Any other direction from council members? Councilmember Alvarez?
More of a question, if I may, Mayor. Examples, as Vice Mayor Rogers correctly stated, as being newly elected, we aren't able to identify lobbyists as well as maybe those who have been on the council or those in government longer than us. And I guess right now you brought up staff. If it's possible, bring up a situation where lobbying is happening even to lower level staff. What would be an example of that?
I think the best example I could give in the main thing front and center, which is why I wanted to talk about it, was the influencing of the staff reports. Council members rely heavily on the staff reports, the data, things that are presented to us. And if there are individuals being paid to influence an outcome who are helping by providing information or talking to the staff member who's ultimately going to write the staff report, I think that council members have a right to know that that's happening. And the public has a right to know.
Absolutely. Thank you, Mayor.
All right. So any other questions? Sorry, Sue, I think I might have a little bit of a delay. Go ahead, Sue.
Okay, I was just wondering, it's interesting too in the comment that staff may be influenced by lobbyists as they're drafting their staff reports, and certainly that can happen. The lobbying ordinance, requires the registrations that are kept at the city clerk's office, so others could, folks can look at that listing. That's public, very public. But the registration, we're not going to necessarily know that they've met with staff. There's not a disclosure requirement, so I just want to note that. So.
Interesting. Then I'd be interested to hear how other cities deal with that issue as well.
Okay. Very good. Okay.
Okay, let's go on to item 4.2.
Great, thank you. Sorry about that. So again, it's going to be a quick overview of the campaign finance regulations. They're contained in City Code Chapter 10-32. And as I'm going through, please again, feel free to ask questions or interrupt. You all, having gone through a campaign, may have a stronger working knowledge of these regulations than even I do. So I welcome any of your input. Next slide. I've included for this ordinance the intent and purpose, and I started bulleting it and I realized, no, actually the statement itself is probably the strongest. And the intent of the ordinance is to avoid corruption and the appearance of corruption by ensuring that the financial strength of individuals or organizations does not permit them to exercise a disproportionate or controlling influence of the election of Santa Rosa City Council candidates. Next slide. The ordinance also goes on to explain that it is intended to reduce the influence of large contributions, to ensure that all individuals have a fair and equal opportunity to participate in elections, to maintain the public trust in governmental institutions and the electoral process, and to increase availability of campaign information. Next slide. It is important to note that it is in addition to all of the campaign requirements under state law. So it supplements the California Political Reform Act and all state law requirements, including the California Political Reform Act and others, do continue to apply. Next slide. Our ordinance applies only to council member elections and to ballot measures that are only for Santa Rosa. So where only the Santa Rosa voters will be voting. those ballot measures are also subject to this ordinance. Next slide. Thank you. So the ordinance requires certain disclosure statements, and that applies to every city council candidate, committee, or other person who's required under law to file a campaign statement, and who has received contributions or made expenditures of $1,000 or more. And once you're in that category, once you're required to file, then you have to continue your regular filings regardless of the level of contribution or expenditure during those later reporting periods. Next slide. Couple of categories of additional reports: late municipal contributions, and those are contributions that are by the candidate, or a committee, controlled committee, totaling the contributions total $100 or more from a single source. They're made or received within 16 days before the election, and it does include loans that are made. So if you fit those categories, you're going to be subject to the reporting requirements for late municipal contributions. Next slide. We also have late independent expenditures. So these are expenditures by independent committees, and they must be reported if they total 500 or more from a single source. They're made within 90 days before the election. Remember, the other one is 16 days. This is 90 days before the election, and they must be reported within 24 hours of the expenditure. Next slide. Late formed committees must report, and the late formed committee is one that has solicited, received, or expended $500 or more and has not filed a campaign disclosure statement or report prior to 16 days before the election. So these are committees that are set up shortly, within a couple of weeks, 2.5 weeks before the election. And those committees must report expenditures, agreements to make expenditures, and receipt of goods or services valued at $500 or more. And they must make that report within 24 hours of the expenditure or the agreement or the receipt. Next slide. The ordinance sets forth contribution limits. So contributions are limited to a total of $500 per election cycle, again, applicable to candidates and to city ballot measures. Contributions are aggregated over time. Loans are considered a contribution unless the loan is made by a commercial institution at rates and terms that are available to anyone in the public. The $500 limit, though, does not apply to the candidate's own personal funds. Next slide. Then the campaign committee, limitations on the campaign committee. Candidate may have only one controlled committee, and the ordinance says per office per election. So if you're running for 2 different offices, which would be odd, only one controlled committee. And then that controlled committee must have a single bank account out of which all expenditures are made. Next slide. Disclosures. So on the disclosure forms must include the name, address, occupation, or employer of the individual contributor. If the information is not on file by the end of the reporting period, then the contribution must be returned. There is a provision for holding on to it for a brief period of time while you're trying to get a hold of the person. But in general, it has to be returned to the contributor. And any cumulative contributions cumulatively totaling $100 or more in the reporting period must be itemized. Next slide. The campaign communications that are funded by independent expenditures. So these are mass mailings that go out to 200 folks or more. They must disclose the full name, address, and phone number of the person or committee that is paying for that communication. And robocalls must include verbal disclosure of the person or committee that has authorized or paid for the robocall. And that disclosure must be made within 48 hours of the robocalls. Next slide. Enforcement. The enforcement is by civil action only. There are no criminal penalties for violation of the campaign finance of our campaign finance ordinance. But the potential civil liability is if you make or accept an excess contribution, you'll be liable for 3 times the amount of the excess or $2,500, whichever is greater. If you fail to include a disclosure on mailers, it's $5,000 for each of those violations. And then all other violations are $1,000 per violation. And next slide, I think we're on to questions.
Okay, council members, do you have any questions? So Sue, one of the provisions, and I don't think it's quite in this ordinance, but it's applicable, is the citizens voter guide and the contribution limit to be able to be in there. Can you discuss that just a little bit?
Sure, and I apologize that I did not include that in the presentation. So I'm going to pull it up because otherwise I'll not know the dollar amounts that apply. But the provision is that if you agree to a spending limit, and I'm looking for the total campaign expenditure limit of $45,000 for the city council election. If you agree to that, then your information will be published in our city update newsletter that goes out near the time of the voter update that goes out near the time of the election. And if you do not agree to that, you will not be included in that voter update. And that, I believe, goes to all registered voters. And maybe it goes to all residences. I don't know, maybe Stephanie, no, she's nodding that it's to all residents.
It goes to all residents, not just not just registered voters. And if you don't agree to the spending limits, your name is still listed as a candidate. You just don't get to put a statement of qualifications, and your picture does not appear in the voter guide. But on the first page, we do list all the candidates, and then there's just a little note that whoever didn't sign it, that's why they didn't appear. Their statement didn't appear.
And we did revise that language. It used to say candidates did not qualify, which suggested that candidates didn't qualify for election. So we did change that language last time around to clarify that it's candidates whose names appear, but not their statements or not their photos. Those are folks that did not agree to the voluntary campaign limitation.
Yeah, I remember that little, I remember that issue back in 2016.
Yeah.
And just to be clear, that voluntary campaign spending limit does change every election. It's based on a formula that I don't remember off the top of my head, but it's with the CPI for the San Francisco Bay Area. There's a formula that we calculate. And then I confirmed that with the finance department that formula and that total amount is correct.
And Stephanie, do you know what that amount is? Because I do see it was starting from January 1, 2011, and then based on CPI.
I can let me see what it was for this past election. I just have to open up my document here.
Yeah, I feel like it was around 54,000 or something.
Yes, yes, I believe so. 54, 56,000, I believe was the total. But I can confirm that while I open up my form from last year, from the last election.
And I asked that question too, just because making no judgment on it, whether or not a change is in order, it does strike me that we've moved into district elections, and yet the threshold to get into the Citizens Guide has not changed. And so that threshold was for a citywide election, and that was still at the time, $50,000 for a citywide election was still a scrappy campaign that required a lot of grassroots. Now it's not that difficult in district elections to stay under that amount.
So for 2020, the amount was 59,187.
Okay. Yeah, and I think I can speak for other candidates that if you have almost $60,000 to spend in 1/7 of the city, and then you still get into the guide, perhaps that's a little bit too easy, and that we should be striving for more grassroots to the extent that we can. And then I'll just, before we go to public comment on this, some of the other areas that I'm interested in this conversation, and part of why I wanted to bring it. One, many elections at the state level allow candidates to gather signatures to reduce the cost to have their name on the ballot. And so even, I believe that the filing fee for candidates is usually somewhere in the $3,000 to $4,000 range. And again, going back to just grassroots candidates, if you can walk and knock on a door and get enough people to sign your signatures, rather than just the 10 that you need to qualify, but actually reduce your filing fee, that's a benefit to grassroots candidates who can't raise the same amount of money, but then can get on the ballot still. So that might be something that we consider. And I want to say it's something like, I'm going to butcher it. It's something like 50 cents a signature off of a $4,000, $5,000 filing fee that folks at the legislature can do, that really encourages you to go out and talk to people up front and try to get signatures. So that might be one that I'm interested in. And then the big one is independent expenditures for the city. We've obviously seen a number of them across Sonoma County. I know that Buckley v. Vallejo and Citizens United make it really difficult for us to do much with independent expenditures because it's protected First Amendment speech. But I am interested in having a discussion about requiring folks who donate more than the $500 to an independent expenditure to have to disclose for the public what their business is before the city, whether it's development projects that they're seeking approval for or permits for, or contracts that they have been approved for. I just fundamentally think that the more information we can give the public on why somebody is having an outside influence on the local elections makes it, it combats the money that comes in because there's that understanding. Are there any questions on those? Okay, I'll go ahead and go to public comment on this item. If anyone is interested, go ahead and hit the raise hand feature on your Zoom, and then we'll bring it back for some additional discussion. I see Gregory's hand.
Thanks, Chris. I appreciate especially your calling out the restrictions on getting your statement of qualifications into the voters pamphlet based on pay. I was the plaintiff in the lawsuit that went to the state Supreme Court, that because I was prevented from getting my statement of qualifications into a Marin County, all county trustee election, the court ruled that the legislature unfairly treated me, and that led to the legislation that allowed signatures. So I'm particularly interested in trying to get statements of qualification, those kinds of statements, into, regardless of what you do. I totally support the signatures, but there should be no difference between candidates based on money. That's what I fought 50 years ago for, and I continue to fight for that.
Thank you, Gregory. That's super interesting. I had no idea. We'll have to talk about that a little bit more next time I see you. Do we have any other hands on this item?
There are no other hands raised.
Okay, I'll go ahead and bring it back. Council members, I've given a little bit of direction to staff. Is there anything additional that the two of you would like to add? Councilmember Alvarez?
Thank you, Mayor. And I appreciate the conversation that's being had today, especially with the statement of qualifications. I recall, and Stephanie can definitely correct me if I'm mistaken, 10 years ago, 12 years ago, there was a way to actually get the signatures for the city council race opposed to just paying the fee. I know that that changed this time around, and I definitely I do see the benefit of the grassroots benefits. My one caveat, one concern is COVID. It's a little bit more difficult to approach the constituents now that nobody wants us to be within 6 feet of themselves. Although moving outside of the COVID, I definitely do see that the importance of the grassroots efforts opposed to the money just being spent. And I definitely appreciate the statement of what business does an outside lobbyist have to do with our local politics. So with that being said, I do appreciate the conversation that's being had. Thank you, Mayor.
Vice Mayor?
I'm a little torn with the contribution limits for multiple reasons. So I know why we have them. I know that it allows more of an equal playing field, I guess, for people to allow for people to gather contributions for their campaign. But if you don't know as many people and not have as large of a circle, it's harder to get $500 from more people or to get as much money from more people. So I don't know, just see how it plays out. And everyone that gives, or people that are willing to give more than $500, aren't always have a motive or are a part of a lobbyist or group. My mom wanted to give me more than $500 because she thinks I'm awesome and she believes in me, but she's not a part of a group. She's just a part of my godmother. She's in my fan club and she loves me. That's why she wanted to give me more than $500. So that's it. I don't know. I'm just torn with the $500. I do think it's needed because I think that it allows people to not just be, I can't just go write Chris Rogers a $5,000 check, right? But then I think that some people need that check for their campaign. So I don't know, makes me I'm kind of torn. So I don't know, especially when you come from a community that is not very versed in the political arena. And so you don't get very many people that contribute to campaigns. And so when you do find people that are willing to contribute to campaigns, and if they are willing to give a lump sum to campaigns, you kind of want to capture that. And if you can only get $500, it's kind of limiting. Then it is limiting when you come from a community that is not versed in giving to political campaigns, if that makes any sense.
It does. We can bring that back for board discussion with some recommendations from staff if that works. Okay. Sue, Stephanie, anything else? Okay. Let's go ahead. We'll schedule for down the road, bringing forward this discussion with some more details fleshed out and some recommendations and perhaps some language too that we can put in place before the next election cycle. Okay. With that, we'll go ahead and jump back. So as was mentioned in one of the comments, folks weren't able to join us for the public comments for non-agenda items. And it sounded like that there was definitely some interest in having that time. So we'll go ahead and open it back up for folks to talk. And I see Pat's hand is up first.
Thank you. I'm Pat Cuda, and I'm co-chair and representing the Santa Rosa Together. I don't know if this fits under this item or if the next steps for Open Government Task Force, it kind of bridges both, but we would like you very much to establish a work plan based on the recommendations of the original Open Government Task Force report and critically review the March 17th staff report and update. The staff report focuses on accomplishments and activities of the Community Engagement Department in the main, but there are notable achievements and deficits in other departments. Specific items we'd like you to look at is the revision of the city mission statement, recommendation from 2017 that we think is very important. Secondly, we'd like you to review the original task force report's recommendations regarding emergency preparedness and utilization of volunteers. The March report really focuses on the activities that the Community Engagement Department did in that area, but again, we'd like you to look broader on what kinds of activities we could be recommending or accomplishments that we've made. Thirdly, we'd like you to consider discussions around community engagement focused charter amendments that could be processed by this committee and maybe formulated. It looks to us like the sections 10.2 that established the CAB does need revision. And I think it's an opportunity to discuss that at this setting or to consider removing it altogether. You know, not having it in the charter, I think would be an opportunity. So I think that, that you should consider undertaking a work plan that really reflects updating the March 17th staff report for a broader focus and clearer identification of future steps from that report. And secondly, really have a broader view when we're looking at engagement, besides putting all the burden and the responsibilities onto the Community Engagement Department. I don't think that was ever the intention of the task force report. Thank you.
All right, thank you so much, Pat. And I know Magali will probably agree with you on many of those points as well, as I see her nodding her head and smiling. We'll consider those as comments, both for this, and I think that you're right. I think that also fits with item number 5 that's coming up. So we'll see if there are any other hands here for public comment for non-agenda items, and then we'll go into item number 5.
There are no other hands raised at this time.
Okay, we'll go to item number 5 on our agenda. That is future agenda items. I will make sure that we note Pat's suggestions for discussion when we make our future agendas here. Madam City Attorney, is there anything, and Madam City Clerk, is there anything that the two of you are interested in having on the agenda, or anything that's sitting that you need a little additional clarity for?
I'm not thinking of anything at this time. We will come back with proposals on the lobbying ordinance and the campaign finance, and we'll look at the proposals from Pat and Santa Rosa Together.
Great.
Same for me too.
Okay. Council members, is there anything that you would like to see added to the agenda that's not currently there? Councilmember Alvarez?
Please correct me if I'm mistaken, but we've been having a lot of discussions about the general updates and a lot of involvement from our community into the process. And part of what I believe, and this could be my misperception, but part of what I believe open government is really our efforts to involve that community. And I'm wondering, how can we strengthen our different departments on being able to successfully achieve their goals, such as Magali's office. And I'm wondering what can we as city council do? And I am depending on really some guidance on what we could do to further their outreach, strengthen their efforts. And I'm wondering I'm leaning on your shoulder here, Mayor. Well, what can we as city council members do to strengthen them, to support them, to really I'm gonna lack of words, but it definitely comes down to the outreach. How can we get to the community? How can we dedicate resources? How can we how can we ask Magali, what do you need and how can we make that possible?
Yeah, I think that it's a good conversation, and I heard it both in Pat as well as in your suggestions. I've got some ideas for you I could throw out right now, but let's go ahead and get an agenda item on there for full discussion and invite the public to participate in that so we can also hear from them how they'd like us to move forward on that. Anything, Vice Mayor? Okay. Well, thank you everybody for joining us. We'll go ahead and adjourn tonight's meeting. We'll work with staff to get some of those things back on the agenda for future agenda items. With that, we're adjourned. See you all tomorrow.